Member for Vieux-Fort South.
Speaker.
Member.
Thank you, Mr. Speaker. Mr. Speaker, by all appearances, this appears as a very innocuous amendment. Very simple, very innocuous. But sometimes, as we know, very simple things portends great complexity and great difficulty. I did, Mr. Speaker, listen to the explanation of the member from Miku South, and to be honest with you, I left very confused. But I guess too with age I get a little more confused more often these days. But you know, Mr. Speaker, the member from Miku South was cautious. While it is true I did not understand his gobbledygook, what he was trying to say, he nevertheless proceeded to suggest that if defects arise, there is always the option of returning to the House and to amend. Now, to some extent, I sympathize and understand, because it is difficult that on this side of the House, there are no lawyers sometimes to take us through the various provisions, and well-intentioned comments are discarded with ease. You know, practicing lawyers, I might want tempted to say, but leave this flood alone. Right. Now, having said that, Mr. Speaker, you know, there is a section in our Constitution, and I don't know whether you've had a chance to look at it, Mr. Speaker, Section 33, which does make the Attorney General, who is a public officer, to be a member of the House. It says, at any time when the office of Attorney General is a public office, as is the case now, the Attorney General shall, by virtue of holding or acting in that office, be a member of the House. And of course, former governments are just as guilty, because we have had Attorney Generals who have been public officers, and we have not made them members of the House, partly because of their own shyness, where they don't want to meet the cut and thrust of the debate. But given the disabilities of the government, it might well make sense for the government to invoke Section 33 and invite the Attorney General to be a member of the House, so that when these debates arise, now what is a member for Castries South East, Mr. Speaker? Could you ask him why is he laughing? Could you ask him to clarify why he's laughing? I have just commenced my address, yes. I said disability. No, to cure the disability. Oh, well, I meant no offense, absolutely. But maybe that could help to resolve and allow for some exchange, and don't place the government at the mercy of the member for Castries Southeast. Mr. Speaker, it is erroneous, plainly erroneous, to say that the legislation introduced by the former government did not provide security of tenure to those employees who will be transferred from medical institutions to the OPU. That is just false. I draw your attention, Mr. Speaker, to Section 34.3. It says, in the plainest language possible, where transfer or secondment referred to in subsection 2 is effective, the rights of the public officer so transferred or seconded to any pension, gratuity, or other allowance for which he or she would have been eligible had he or she remained in the public service are preserved. How then can you stand up in this House and say that they had no security of tenure? The language is pollusively clear. Very, very clear. The question that arises now is whether we achieve that security of tenure better by this amendment to remove the word transfer and to use the word secondment. That's the issue. That is a fundamental issue. Now, Mr. Speaker, what does secondment mean in ordinary language? What does it mean? What is the dictionary meaning of the word secondment? Secondment means a person's reassignment from his or her regular employment to some temporary assignment elsewhere. That's what secondment means. And in the public service, when we have used the term secondment, we have always meant, we have always understood it means reassignment to some other position, but for a temporary basis, for a period, a specified period of time, renewable or otherwise. Now, the amendment uses the word secondment. It removes the word transfer, speaks of secondment, but of course chose not to define secondment. Of course, law can say anything. Even can say what is foolish, as you know. I mean, you could have had a definition of secondment to mean something else. But the reality is that if you are using the word secondment, then you're importing the ordinary meaning of the word secondment, unless of course you ascribe some other meaning. The question I think that the member for Swazelle really should have put, and I invite him to reflect on it, is there more or greater security of tenure when nurses are transferred or seconded? That's the question. Is there more security of tenure when the staff of Victoria Hospital and Allied Health Services are transferred as against secondment? That's a fundamental question. Now, Mr. Speaker, it is well known, Mr. Speaker, that the model that the former government used to deal with the staffing of the OKU was in fact the precise model, or almost precise model, maybe with some variation, that was used at the Sir Arthur Lewis Community College. When persons who were public officers in education were transferred to the Sir Arthur Lewis Community College, there was a similar provision in the Act that sought to protect the security of tenure of those individuals at Sir Arthur Lewis Community College. There's no issue of privatization of Sir Arthur Lewis Community College. It was remain a government institution. But that was the logic, that was the history, that was the pattern, that was the, shall we say, the precedent that we utilized. Subject, of course, to other more recent pronouncement on the courts regarding what transfer meant. Mr. Speaker, I think we need to be very careful what we are doing. And I want just for a moment to go back to the Constitution of the country and to the powers of the Public Service Commission. Since in either case, if you're talking about secondment, it appears that you have to be relying on the Public Service Commission. If you're talking about transfer, you're dealing with the same thing. And if I may, Mr. Speaker, the relevant provision of the Constitution is Section 86. And a similar provision exists in respect of the Teaching Service Commission, but it's not material here. Mr. Speaker, it says, the power to appoint persons to hold or to act in offices in the public service, including the power to confirm appointments, and subject to the provisions of Section 96 of this Constitution, the power to exercise disciplinary control over persons holding or acting in such offices, and the power to remove such persons from office shall vest in the Public Service Commission. That's what it says. Now, curiously, Mr. Speaker, the section I just quoted makes no reference to the power of the Commission to transfer. But it has been accepted that you can appoint a public officer from one post to the other on transfer. So the clear suggestion has always been that the power to transfer, though it is not mentioned in the provision, is implicit in the power to appoint. That has always been a fundamental point. You don't see any reference any power to a power of secondment. Unless you are now prepared to say that if you argue that there is a power of transfer, then automatically you must also argue that there is a power of secondment. That it is also implied, significantly implied. But then, if that is so, understand that the notion that you can second for a temporary period, then that notion has to be revisited. Now, to the credit of the draftsman of this bill, and I concede this, the draftsperson of the bill says that the person would be, shall we say, seconded on the written consent. In other words, if, as we suggest, that secondment is for a specified time, then what a nurse, a doctor, or health practitioner is doing, saying that I am consenting to leave my post as a public officer, protected by the Public Service Commission, I'm going to go across to OKEU, but only for a specified time, and I'm agreeing to do this. But does the person still remain under the jurisdiction of the Public Service Commission is a fundamental question. Do they remain under the jurisdiction of the Public Service Commission? It is because we were aware of these differences. Differences of transfer, differences of appointment on secondment, that we use the two terms transfer or seconded. So in effect, what we were doing was to give the public servants far greater security of tenure. And that is why I think you then have to ask yourself whether a public servant who is appointed by a Public Service Commission has greater security of tenure by virtue of being seconded. What are the implications? Now, Mr. Speaker, I had a member for Miku South saying, well, you know, we had to do this because of the Pensions Act. The Pensions Act is ordinary legislation, you know. Some people behave as if the Pensions Act can't be touched, that you can't amend the Pensions Act. If, therefore, you had a problem with the Pensions Act, to ensure that you give the nurses and doctors and others the security they need, amend the Pensions Act. Leave this alone. What are you interfering with that for? Why you need to interfere with it is a question. Now, sometimes the exchanges between parliamentarians often help because they clarify objectives and purposes. The member for Castries East, the leader of the opposition, and to some extent the member for Denry North, challenges the member for Castries South East and says, well, you want to use the term secondment to better facilitate privatization of the OKE. Now, he admits that. He says so. He accuses us of saying it, attacks us for saying it, spreading all kind of propaganda, but in the end he says, well, that is to facilitate that. Mr. Speaker, if I'm misleading out, you ask me to withdraw, you know. But I know you are listening to him as you are now listening to me. So that is his point, that is his thrust. So where has, therefore, the leader of the opposition caused any unnecessary mischief in his presentation? Now, Mr. Speaker, it is a case that this House does not take any advice regarding legislation from the opposition. And I suspect that it has to remain like that for some time until something happens along the way, and then you have to come back to the House to seek redress. Now, I couldn't believe what I was hearing this morning from the member for Castries South East. He's a seasoned parliamentarian of great dexterity, shall we say. He's a seasoned parliamentarian I couldn't find a more neutral word. That's not the word I want to use, you know. But for purposes of the House, and not to antagonize the Speaker this morning, because I see he's trying to rein in what he hasn't done in the past, he's doing today, rein in the debate to keep it on a straight line. And I applaud him, I support him. So I will retain the word dexterity. Now, the member has the audacity to stand in this House and say, when the former government passed the Millennium Heights Medical Complex, what you did was in effect privatized. No, Mr. Speaker, that's absurd. And the absurdity is reflected when he says later in his presentation, but what you did was statutorize. It is perfectly the case, Mr. Speaker, that I'm rather amused by that. Thank God, some people have more than one. You see, thank God people have more than one. Now you see where he goes, and you're quiet.
I'm just trying to get you focus on yours.
But in time. But that having been said, Mr. Speaker, let me say that there is no argument to sustain the point that you are privatizing the Millennium Medical Heights Complex. The statutory board mechanism has always been used by governments to express their legal personality. In fact, Mr. Speaker, there are occasions when a government may decide not to go by way of statutorization and establish a company which it owns to manage its business and take on the clothing of a private sector entity or a corporate entity, as the case may be. And there are several. But this can never ever be said not to be a statutory entity, a government entity. And in fact, the whole objective, Mr. Speaker, of Section 34(3) is that when the nurses, doctors, and other health practitioners are transferred to the OKEU, although they are under the direction and employment of a board, but in terms of the powers of discipline, dismissal, and pension, they cannot interfere with those transferred officers. That has to be handled differently. And why you did that? For the very simple reason of trying to avoid the complex constitutional issues that will rise over security of tenure. Now, the member draws attention to clause 34. And this is what it says. Subject to subsections 2 and 3, an employee of the board other than an employee under the subsections 2 and 3 shall be employed by the board on a contractual basis. To distinguish between the new employees, the new doctors, the new nurses, the new technicians, the board was given the power to employ these persons, but employ them by way of a contract. This clearly is distinguishable from those officers who in fact have been transferred from allied institutions, and I'm referring to Victoria Hospital, Turning Point, and the rest of it. Mr. Speaker, question is, where does this leave us at this stage? Where does it? It's a complex issue. I'm the first to admit it is a complex issue. But I believe that this is not the approach that should be taken. And unless we can get the legal clarity we need as to what secondment means in this context, what flows from it, I would urge that some caution be exercised. Now, there's nothing to prevent a nurse at Victoria Hospital saying, listen, I don't want to face all this tralala of being transferred from Victoria Hospital to OKU. I prefer it differently. I could resign, I could retire, but then I will prefer to be employed by contract. These are the things that we have to look at. And so I really believe that this will end up, as it is, causing more problems than it resolves issues. Now, Mr. Speaker, if that was not the case, why on earth should the Public Service Commission be involved in secondment? Why? Because it is an admission of the powers of protection that a Public Service Commission has over a public officer which it has appointed on a pensionable basis. And this, in my view, is denuding, stripping the public officer of all the protection that that public officer enjoys. Of course, you can all go ahead. The majority speaks. The majority could proceed, as has happened in other cases. You can do that. And then, of course, the consequences come later on in due course. But you hear in these debates all kinds of things. And the time, I'm sure, will come when there will be a big debate on St. Jude Hospital in this house. It must come. But you know, we owe it to those people who are involved in the construction and the management of St. Jude to speak the truth. No matter, Mr. Speaker, whether we don't like the job that they did, and the curious thing for me has always been the fact that all the consultants at St. Jude's were consultants appointed by them, you know, which the former government met, every one of them. All the consultants were appointed by the former government. But to suggest, as I heard this morning, that we proceeded to reconstruct St. Jude without consultants and advice is not true. Accreditation. Wish to, on a point of order?
Yes,
of course I will give way to you.
Well,
Anytime.
Very well, Member.
First, Mr. Speaker, I would like to seek clarification from the Honourable Member as to whether the statements he's making, is he attributing it to my comments? I'd like to know that to begin with, Mr. Speaker, if he may be kind enough to provide me with this information.
Mr. Speaker, I refer to comments made in this House earlier, which stated that when the former government, was engaged in the construction of St. Jude, we never got proper advice from consultants. Correct, Mr. Speaker? You heard that, didn't you? All right. Now, all I'm saying is that that is inaccurate. That is inaccurate because the then government utilized the services of Accreditation Canada to advise it on the hospital, the design of the internal structures of the hospital, and so too did the Island Paho. Now, we can sit in this house and denounce whatever they provided, but in time the debate will come. The debate must come. But at least concede what the truth is in these matters. So, Mr. Speaker, at the end of the day, I don't buy the explanation provided by the member from Eagle South. It doesn't help. I believe that this has placed these civil servants in a far more vulnerable position. And very clearly, I would urge that if any amendments are to be made, that the language should be as in the Act, transfer or secondment, as the case may be, with a possible definition of what you mean by secondment. Mr. Speaker, I regret. It doesn't matter though. I can't lend my support to this bill. It doesn't matter at the end of the day. But I think this bill is defective. I thank you, Mr. Speaker.